Lisa and I are going to be speaking to you today about maternity and birth injury claims, which of course is a very important topic in clinical negligence claims. And overall, we're going to be bringing you up to date on 5 recent, interesting and quite frankly precedent-setting cases from the High Court and Court of Appeal, with important points for you to take away from both a claimant and defendant perspective. So I'm going to start with the first slide. If I do that or that. Interesting. There we go. All right.
The only technical glitch.
So maternity and birth injury claims, I thought I would ease us in with a few key stats of the nice, easy kind. Interestingly, NHS Resolution report from 2021 to 2022 says that maternity-related claims make up 62% of the total number of clinical negligence claims. And having had a look at their more recent report in 2022 to 2023, that figure stands up as well. Clearly, one of the key challenges for the NHS is the increasing demand for maternity services, which clearly puts a strain on resources and staffing levels. And of course, staffing levels is often a key factor in many clinical negligence claims, and not just in respect of maternity and birth injuries. Another interesting stat, I thought, particularly for litigators in the 2021 to 2022 report, is that 77% of clinical negligence claims are settled without court proceedings. And I would certainly anticipate that to be of a similar figure in subsequent years, in subsequent reports. So I thought that was quite interesting. And I hope it will not have escaped anybody's remit that these types of claims have been brought to the attention of national news, and they've remained national news, particularly with the Donna Ockenden Independent Review of Maternity Services at the Shrewsbury and Telford Hospital NHS Trust, which was published in 2022 in March. And there have been other similar reviews by Donna Ockenden and other into other trusts concerning maternity services. So that really gives us a framework of the importance and the prevalence of maternity and birth injury claims in the clinical negligence sphere. So if I go to the next slide, perhaps unsurprisingly, but certainly welcomed, in the spring budget 2024, we've got a nice photo there of the Chancellor. On the 10th of March 2024, the government announced that they would be investing 35 million to fund specialist training for staff and additional midwives to improve maternity services. A further 9 million dedicated to prevent avoidable brain injuries in childbirth, with the anticipation and hope that women's voices and experiences are to be prioritised with the funding allocated to improve care. And all of this is to be provided over the next 3 years. So it's really with that announcement in mind and the importance of this area in clinical negligence claims that Lisa and I thought it would be important to bring you all up to date on various recent legal developments. So I'll start to take you through some of the important cases that we want to refer you to today. The first case I'm going to take you through is CDE and Surrey and Sussex Healthcare NHS Trust 2023. This is a Court of Appeal case. It is an appeal from a first instance decision of Mr. Justice Ritchie in the High Court, and it is a very interesting, rare example of a successful appeal against findings of fact. So if I just go through a little bit of the background quickly, the claimant suffered a severe brain injury around the time of her delivery. She was born by C-section, having suffered profound hypoxic ischemia before, during and following birth, which was, and I say the time now because it's going to become very relevant, at 1748 or 1749. As a result of this injury, the claimant suffers from quadriplegic cerebral palsy with severe global developmental delay. Now, the claimant's case at trial was that following the mother's admission to hospital at 36 weeks and 1 day, as a result of negligent care, the claimant's delivery was not competently managed. There was a delay in the delivery of the claimant, which resulted from a delay in transfer of the mother to the labour ward, and thereafter a delay in commencing the monitoring of her heart rate during delivery, which caused or materially contributed to the injury. Now, the timings in this case were key, as they often are. So the sequence of events from 4:50 p.m. to delivery of the claimant at 6:08 was critical to the assessment of what in fact happened and what should have been done by those at the defendant's hospital responsible for the care of the mother and her child. So Mr. Justice Ritchie made detailed findings and facts. The emergency occurred just as the mother was arriving on the labour ward at 5:49. On detecting the bradycardia, it was found that the midwife who was on the labour ward at that time would have called for an obstetrician within 1 to 2 minutes, or in a maximum of 3 minutes, and that the on-duty consultant would have entered the mother's room at 5:52 upon hearing the bradycardia. Now, bradycardia is, of course, the reduction in the fetal heart rate. Now, the reason why I've highlighted that sentence is because that is the key finding of fact that was turned over on appeal. And Mr. Justice Ritchie found that it would have taken 17 minutes from that time to the delivery of the claimant as it did in real life. So the judge did make findings on breach of duty. He held that the claimant's claim failed on factual causation. He found that on the balance of probability, the baby would have been born brain damaged in any event. The brain damage was caused by the PHI, the profound hypoxic ischemia, and this would have occurred even if the defendant's staff had not been negligent in their care for the mother on the antenatal ward before the bradycardia had started. So that just gives you a little flavour for the background of this case, that breach of duty was found, but the claim failed on causation. So the claimant sought to overturn that finding of fact as to the time that the on-duty consultant entered the mother's room on hearing the bradycardia coming from the transducer. So that key time was 5:52. Now, In respect of findings of fact, appellate courts will not interfere with findings of fact by the trial judge unless compelled to do so, or they were plainly wrong. And the warnings have been set out in that case there, which I'm not going to attempt to pronounce the first word. But essentially, the warnings are that the expertise of a trial judge is paramount in determining what facts are relevant to the legal issues to be decided. A trial is not a dress rehearsal. It is the first and last night of the show. I quite liked that phrasing. So that is a direct quote from that judgment. That the duplication of a trial judge role on appeal is a disproportionate use of the limited resources of an appellate court. It will seldom lead to a different outcome. Really, it is the trial judge that has the benefit of hearing the whole case and having regard to the whole of the sea of the evidence presented to them, whereas an appellate court would only really be island hopping. And that an atmosphere of a courtroom cannot be recreated by reference to documents. So that really is the approach of the court when looking at whether or not to interfere with findings of fact and whether or not it's compelling to do so. Of course, the second part of the test is whether it's plainly wrong. That's quite simple. Henderson and Foxworth Investments Limited, 2014, the Supreme Court set out the test for that. It does not matter with whatever degree of certainty that the appellate court considers it would have reached a different conclusion. What matters is whether the decision under appeal is one that no reasonable judge could have reached. So those are the two important aspects of the test to take into account. So turning then to the grounds of appeal, well, eventually this appeal turned on a very narrow issue. Did the judge fall into error in finding that the on-duty consultant would probably have walked into the mother's room at 5:52? Well, Lady Justice Nicola Davies was giving the lead judgment, and she reasoned that the consultant, Miss Nix, who I have just put down there as N for ease in the slides, had been outside the mother's room at 5:50, and that had been a finding of fact by the judge at first instance, because that was the timing of the start of her notes. And so on hearing the bradycardia coming from the mother's room, would have immediately entered the room and would have done so by 5:51 and not 5:52 as was found at first instance. There was no need for Mr. Justice Ritchie to postulate what the midwife would or should have done when the trace became bradycardic at about 5:49. So the judge incorrectly applied the Bolam test as to what a reasonable midwife would have done in waiting perhaps 1 or 2 minutes or a maximum of 3 to get obstetric assistance, when on the facts it was more akin to a Bolitho scenario, which is what the consultant, Miss Nix, would have in fact done. On the evidence, it was known what Miss Nix would have done, and had she heard the bradycardia at 5:50, which would have occurred on the but-for scenario, then she would have gone into the mother's room by 5:51, which would have led to a saving of 1 minute and delivery of the claimant 1 minute earlier at 6:07 rather than 6:08. So that was the flaw in the judge's reasoning. An incorrect finding of fact, perhaps, but Nevertheless, an error occurred and 1 minute was lost. So the appeal was allowed, but the real question was, what would 1 minute have made to the issue of medical causation? Now, because the experts at trial hadn't addressed this, the case has been remitted back to Mr. Justice Ritchie for specific consideration. Now, key points to take away from this case of CDE: there remains a very high bar for turning over findings of fact. In fact, only one finding of fact was overturned in this case, but it had clearly an effect on causation. So it's very crucial to ensure that the correct test for causation is applied at all relevant points in the chronology. Here, the error was in applying the Bolam test to a situation which was more akin to a Bolitho one. It was also quite clear, if you go back and read the judgment, which I certainly advise you do, that the claimant's case on when delivery should have happened evolved significantly from the particulars of claim to several different amended particulars of claim at trial and even at appeal. So from a claimant perspective, one of the takeaways from CDE is really that causation may not fully crystallise until the trial judge has made findings of fact and findings on breach. Therefore, perhaps for some claimant lawyers, it may be prudent to not pin one's colours too rigidly to the mast in the pleaded case, and to carefully think about pleading alternative counterfactual scenarios so that those are there in your particulars of claim for you to rely on should it be necessary. So moving on then to the second case that I'd like to take you through today. This is CNZ and Royal Bath Hospital's NHS Foundation Trust 2023. This is a High Court decision, and the key issues in this case are really about consent, causation, and material contribution. Interestingly, this is another judgment from Mr. Justice Ritchie, but this time looking at it at first instance rather than appeal. Looking at the background of this case, the events that the court were dealing with occurred 26 years ago, with the birth of twins on the 3rd of February 1996. Twin 1 was delivered healthy at 1 minute past midnight, and twin 2, the claimant, was born just over an hour later at 3 minutes past 1. The claimant suffered from 16 minutes of acute profound hypoxic ischemic insult, PHI, which began at 12:50. So in terms of the PHI, this continued for 13 minutes before birth and 3 minutes after birth. And as a result of that injury, the claimant has quadriplegic cerebral palsy. The crux of the claimant's claim was that she had requested a C-section, but this was refused or delayed by the clinician. And when the hospital did deliver the claimant, the delivery was carried out negligently as it was late and caused the hypoxic ischemic insult. So, findings of fact. Again, the timing is key, as it is in many of these cases. I'm not going to go through all of the findings of fact in this judgment because it was 107 pages long and 407 paragraphs. So I've distilled it into 4 bullet points for you. By 26 minutes past midnight, twin 2, the claimant, was still not born, and the doctor opened up a conversation with the parents about a caesarean section. The parents had said words to the effect that they had thought that was necessary from the start. However, at this point, the doctor did not explain the risks and benefits of the treatment options to the parents, which the judge found she should have done, and she should have asked for those choices. Had the options been explained and the parents asked to choose, then they would have chosen a C-section, as they did in real life 9 minutes later at 35 minutes past midnight. So that was the aspect of the judgment that was really dealing with consent and informed consent. So the total negligent delay caused by the numerous breaches by the clinician was 6.5 minutes. The breaches included failure to discuss reasonable treatment options with the parents, fully informing them of the risks and benefits of the options, allowing them to make an informed choice, failing to act on that choice, and failing to act urgently. The claimant should have been delivered by 55 minutes past midnight or 58 minutes past midnight. On the but-for prognosis, had birth been achieved earlier, the resuscitation would have been reduced by 1 to 2 minutes. Therefore, had the claimant been born in that period, it would have been in the non-injurious phase of PHI, and the judge found that the first 10 minutes of PHI were non-injurious, so from 50 minutes past midnight to 1 o'clock, the following 6 minutes were injurious. So the delay caused by all of those breaches was causative of the whole of the claimant's brain damage, as a saving of 6.5 minutes would, on the balance of the probabilities, have avoided all of the claimant's brain injuries. So just a couple more slides on this case. So dealing with the but for causation. So having made those findings, the interesting part of the judgment is really in respect of causation, divisible injuries and material contribution. Was the evidence sufficient to prove that the breach-related PHI caused injury to the claimant rather than the non-breach PHI? Well, it was agreed that every minute of acute PHI over the first 10 minutes caused increasing or incremental brain cell deaths. The damage minute by minute was more than de minimis. The claimant's expert advised that minute by minute damage could not be defined in terms of the level of impairment in the different domains of development. He was clear that the longer the duration of the PHI, the more injured the brain would be, and the greater brain damage suffered by the claimant, but the functional disability was just not predictable. So the judge did find that each minute caused increased functional outcome, disability, and injury. The interesting part here, however, is that the judge found that medical science is unable to identify with generality, accuracy, or detail the functional effect of each minute of brain cell deaths. So then the key question was about material contribution and apportionment. In principle, the defendant should only be liable for the brain damage which it has caused and not that which would have occurred in any event. And the question really was, should damages be apportioned in this case? Well, Mr. Justice Ritchie found that it was impossible to differentiate between the negligent and the non-negligent damage. He found that there is a scientific gap making proof of causation of functional outcome and quantification impossible. And as such, the claimant should recover 100% of the damage she has suffered due to the acute PHI, as long as the claimant can prove that the breach made a material contribution to the reduced functional outcome, which was more than de minimis. So this does set a very interesting precedent, but of course the court could still take a pragmatic approach to apportionment and assessment of damages. Interestingly, permission to appeal was sought by the defendant in this case on this issue of apportionment. And I understand that that has been heard by the Court of Appeal and we're awaiting judgment. So again, watch this space. So finally, just to conclude on this case, to both claimant and defendant lawyers, the material contribution test is very important in these types of cases, and it's key to ensure that your expert evidence considers both whether the but-for causation is established and addresses material contribution in the alternative on all realistic counterfactual scenarios and findings of breach. And secondly, and specifically arising from this case, it's important to be aware of the distinction between divisible brain injury caused by PHI and the indivisible functional outcome, where it's not possible due to the scientific gap to determine the extent of harm arising from the negligence or non-negligence. So thank you for that whistle-stop tour through two cases. I'm going to pass you over to Lisa.
Thank you, and thank you for that, Francesca. I am going to take you through 3 additional cases. It's been a busy 12-month period throughout 2023, early 24, for maternity claims. There are 3 more important cases that I will summarise and take you to the key issues. And then I will go on to some hints and tips for bringing these claims and defending these claims, and also some things to look out for in the next 12 to 24 months that we see on the horizon in maternity claims. I should also say that these slides will be circulated following today's talk, so please don't frantically feel that you need to be jotting any of this down. We will circulate it so you'll have the references and hopefully you will find that useful. The first case I want to refer to is the case of Callahan and South Tees Hospital 2023. This is really a case, it deals with breaches of duty and findings of fact, but it also has an interesting discussion on expert witnesses, which I will come to. It's a very sad case. It involves the death of a newborn baby at 7 days old. For all intents and purposes, that child was born well and healthy. It was discharged at 2 days old and was readmitted to A&E within 24 hours with deterioration and had, in fact, was suffering from bacterial meningitis and septicemia and later died at 7 days old. The allegation was that the child was not feeding well whilst an inpatient in the first 2 days of life. And because the baby was not feeding well, there was some discussion about whether it was a difficulty of feeding or poor feeding, and that the judgment goes into some detail in relation to that. But the claimant's case was that in light of the difficulties in feeding or poor feeding, the child should have remained an inpatient until a normal feeding pattern was established. And if the child and mother had remained as an inpatient, then when the child deteriorated or began to suffer from the symptoms of meningitis and septicemia, they would have been an inpatient, that would have been picked up early on observations, and death would have been avoided. Now, there was a lack of record of feeding overnight in the night preceding discharge. And the claimant's expert in the case of Callahan had made an assumption that that 14-hour period where there was no record of a feed or an estimate as to the amount that had been ingested meant that the baby had not fed during that time. And that was quite an important feature of the claimant's expert evidence, because it then fed through into the conclusions as to what a reasonable midwife, how they would have exercised their clinical judgment in light of that. But in fact, the trial judge, who was Mrs. Justice Ellenbogen, who gives a very detailed judgment and sets out very clearly the arguments presented by both sides and considers them very carefully, there was evidence that a feed had taken place during that 14-hour period, even not expressly documented as such within the notes. For instance, a wet nappy had been documented. there was some discussion about a reference to the baby choking and a teat being changed on the bottle. And these were all considered as part of the evidence as to whether some form of feeding had taken place. All the evidence had suggested that the baby had been clinically well prior to discharge and the claimant was not advancing a case otherwise. And the expert evidence came to the conclusion that poor feeding was one clinical sign, not a red flag, just one clinical sign of meningitis. And in fact, what the guidelines at the time, the NICE guidelines and the internal guidelines had said was that you needed 2 clinical signs in order for further monitoring to be mandatory. Here you had one clinical sign. And so, in fact, it was an exercise of clinical judgment for the midwives at the time to decide what to do in this instance. And as we know, the baby was discharged with advice. There was a finding of fact that the advice provided wasn't sufficiently specific. So the mother ought to have been advised that feeding should have taken place approximately every 3 to 4 hours. And it was a little bit more vague than that, but nothing causatively turned upon that. I think this case is interesting for the discussion about the experts and the findings of fact. Now here, the claimant made a submission that the defendant's expert evidence should either be not admissible or less weight should be attached to it because the defendant's expert, it was said, was either speaking outside of her area of expertise or she didn't have the sufficient expertise as a practicing midwife during that period of time. So the relevant period was 2014 and the NICE guidelines were dated 2012, and it was accepted that the defendant expert was not a practicing midwife at that time. However, when one reads the judgment of Callahan, it can be seen that the claimant's expert actually fares worse than the defendant's expert at trial, despite the criticisms that were made by the claimant's counsel of the defendant's expert. And why is that? That is because the claimant's expert in this instance made the assumption that the 14 hours of a lack of entry relating to the feed must mean that there wasn't a feed at that time. And that then fed through into the claimant's expert's opinion as to how the clinical judgment ought to have been exercised when considering the one clinical sign. What do I say you should take away from this case? As I trot through these slides and the subsequent cases that we've seen in 2023, there is a very clear emphasis on the need for experts to be experienced and practicing at the time of the issues being considered, and to have the relevant expertise that is going to assist the court. So I make these points with a little caution because it seems to me that the defendant in some cases may have been at some risk with an expert that wasn't practicing at the relevant time. However, the claimant's expert in this instance fared worse because she had made this assumption on the facts and then it had fed through into the opinion on clinical judgment. What I say to my clients when I'm dealing with cases for claimants and defendants, with each expert, you need to make sure that when you're dealing with the facts, that they are considering them in the alternative. So if the court finds X, then my opinion is Y. And then the alternative, if the court finds Y, then my opinion is X, and turn it on its head. And so you and the court have the range of opinion that could arise from the range of factual findings. And you will need that going into any negotiation and going into certainly any trial. And that will then give you the basis for whether you need a range of opinion as to what a reasonable, in this case, midwife, ought to have done when exercising their clinical judgment. And if you take it through that in small incremental steps, you will have all of the evidence you need and know your strengths and weaknesses. The second case I wanted to discuss with you is the case of CCC against Sheffield Teaching Hospitals NHS Foundation Trust. There are 2 judgments, one dealing with Part 36 offers, which I will come to. This is the case that deals with the assessment of quantum. I doubt that anybody practicing in this field has missed this judgment. It really is a must read. It's a long judgment. You'll need to read it with a strong cup of coffee or even something stronger. Take your time. There are many issues arising from it. On this slide, I've highlighted a non-exhaustive list of some of the key elements that it will assist you upon, and I'll take you through some of them. But frankly, the case of CCC is an hour-long discussion in itself. And we could just have one webinar simply on this case, but I will take you through some of the key points that I think will impact upon the majority or certainly plenty of your cases in this area. It's the first quantum case to have been decided since the case of JR against the same trust, Sheffield Teaching Hospitals, in 2017. And so if you want to go back and read that case, it provides useful background, and you can see the development of the law and issues relating to quantum in CCC. As you can see, the key points, no deduction on past gratuitous care, and I will come to that in a moment. By that, I don't mean no deduction on the hours claimed, I mean no deduction in terms of percentage reduction to reflect the fact that it is gratuitous care. Rule of thumb being 25%, and I say rule of thumb, but we'll look at that in a moment. The hydrotherapy pool claim was successful. The claimant's claim for 2-to-1 waking nighttime carers was successful. The accommodation costs were not reduced. No deduction was made for the rent that parents would have otherwise made. There is a lost years claim, which is subject to the leapfrog appeal up to the Supreme Court, which I'll come to. And a very important feature of this judgment are the critical findings in relation to the defendant's expert evidence. And I just pause here to make a point that when reading CCC, without doubt, it's a great victory for the claimant. However, I think there are some very useful takeaway points for both parties as to how their cases can be best presented. And as Francesca touched upon at the beginning of this webinar, the vast majority of these cases don't make it to court. They are negotiated in mediations and JSMs or roundtable meetings. And if your evidence is in good shape at that negotiation stage, you stand a better prospect of negotiating a good settlement for your client. If you have the sort of gaps in your evidence or the risks in your evidence that were in part a play for the defendant in this case, then you run the risk of a less good settlement at that stage, or even of the claimant taking a chance and going to trial. So without further ado, I'll move on to the first issue that I've decided to explore in a little bit more detail, which is the claim for a hydrotherapy pool. Again, His Honour Judge Ritchie, who features strongly in the last 12 months of maternity claims judgments, identified these two issues as such. Does the claimant have a reasonable need for the expense as a result of her injuries, pain, suffering and loss of amenity, with the twin aims of gaining some benefits and taking steps towards putting her back into the same position she would have been in but for those injuries? Then, is the claimant's expense reasonable compared with other less expensive methods of satisfying the reasonable need and taking those steps? Now, sometimes hydrotherapy pool claims are added on to a schedule of loss, and they do very much feel like an add-on, and they're not adequately evidenced, and it's easier for defendants to oppose that head of loss. But in this case, the claim for hydrotherapy pool at the claimant's home was very carefully considered, carefully evidenced in the factual witness statements, and carefully supported with the medical evidence and indeed video evidence in this case. So it was argued by the claimant, this was the only environment in which the claimant would undertake any form of exercise, and that immersion in water brought her pleasure, a degree of freedom, societal participation with her family, and other physical benefits. And that was evidenced through the medical evidence showing the need and the benefit to be gained from the hydrotherapy pool and the immersion in water. There was very convincing video evidence as to how the claimant reacted when immersed in the water, and the benefit that she gained from that. And then that was supported, completing the jigsaw with factual evidence from her family. The claim itself came to a total of 607,000, a little over 607,000 for the installation, and annual costs of 17,385 per annum, which if one looked at the multiplier, gave you a figure of 368,000 and a little over. His Honour Judge Ritchie pointed out that the defendant had failed to prove reasonable alternative provision. And so it's a warning to defendants that where you are presented with a claim for a hydrotherapy pool or something similar, and it is properly evidenced by the claimant, so there is a need, usually a medical need or benefit associated with it, and the costs are set out clearly, you need to be meeting that with the same level of detail. Is there a medical need? If not, your medical experts need to deal with that. If there is a medical need, but there is a reasonable alternative provision that can be provided, you need to deal with that in your evidence. And it's not just a case of saying, looking online and your experts providing the nearest resource for a hydrotherapy pool. You need to look at the facilities, the practicalities, whether that environment's noisy, whether it can be exclusively used by the claimant at times that are going to be suitable to them. All of that needs to be covered in order to try and persuade the judge that if there is a need, then there is a reasonable alternative which will have much the same benefit but a lesser expense, because the claimant doesn't have to forego the benefit just because it's cheaper, and it does need to be that detailed. His Honour Judge Ritchie said that he hadn't been provided with the relevant evidence to conclude whether there was a reasonable alternative provision, but he proceeded to estimate the alternative provision costs and awarded the claim for the hydrotherapy pool. Gratuitous care, now this is an issue that's going to filter through to all of the clinical negligence cases, not just in maternity claims that you're considering. We're all following the 25% rule of thumb. NHSR will often suggest a 33% reduction because, as you can see from the case of Nash versus Southmead, a 33% reduction has been known to be made. But when you read CCC, there really is a careful analysis of the going back to basics in care claims as to why a reduction is made, in what circumstances it may be appropriate to alter the rule of thumb and why, and what evidence might lead a judge or a party to do so. So it is worth reading that with some care. C argued in this case for a 0% reduction for gratuitous care to reflect the complexities and challenges faced by her family in providing care before the commercial care was put in place. And that's because effectively mother and some of the other family members were acting as mother, carer, case manager. They really were keeping the claimant alive and providing her with some quality of life and working incredibly hard to do so. And it entirely changed their family dynamic. And that needed to be reflected, the claimant said, in a full award for the full rate for gratuitous care. I've set out there the cases that are referred to where we have seen different deductions made, and you may want to refer to them in subsequent cases. Going back to the basics, because it is worth highlighting, Housecroft and Burnett, 1986, the court should look at it as a whole and consider whether, on the facts of the case, it is sufficient to enable the plaintiff, among other things, to make reasonable recompense to the relative. Where given up work, natural that the plaintiff would not wish the relative to be the loser and the court would award sufficient to enable P to achieve that result, the ceiling would be the commercial rate. And then in Evans, circumstances vary enormously, and what is appropriate and just in one case may not be so in another. The services are not in fact being bought in the open market, so that adjustments will probably need to be made, probably. But such adjustments are no more than an element in a single assessment, not by means of a conventional percentage. Now, the factors which His Honour Judge Ritchie identified are set out summarised at paragraph 146 of this judgment. The commercial value is assessed gross, so there are no tax and national insurance. One needs to take into account the weight, complexity, difficulty, nature and intensity of care. They may vary between equivalent of nursing care and a low level of fetch and carry support work. The hours when the care was provided needs to be taken into account, and we see that anyway as to whether you were using an aggregate rate or a blended rate. And other calls on time of the caregiver juggle with an income forgone. So if they have given up work, or if there are other children in the family, or if they're providing care in both directions, so they may be providing care to parents as well as to an injured child, all of that needs to be taken into account. And the fact due to some love and support, some care but for, and whether the parent has lived rent-free as a consequence of an incidental consequence of the injuries. All of that needs to be factored in when considering whether to make a deduction, and if so, to what extent. Now, obviously, a 0% reduction for the claimant is a great success, but in birth injury cases where, and this is a maximum severity CP case, so it's not going to apply in all cases, but where you think it might apply, you really do need to cover all of these points in your factual evidence. And of course, for defendants dealing with these cases, the percentage reduction can work both ways. So whilst not in a maximum severity CP case, but in your other maternity claims, or indeed your wider clinical negligence practice, you can take forward some of this discussion on percentage discounts for gratuitous care when considering your counter schedule of loss and what level of deduction could be made. Because if it is of the fetching and carrying sort of care, which is very occasional, then you could, I suppose, argue for a higher deduction, such as the 33% that we've seen in some cases. So it can work and operate in both directions. Nighttime care. Forgive me, I'm just going to take a drink. As is often the case, the care evidence was diametrically opposed. So the claimant relied upon a report from Maggie Sargent, who I'm sure you're all aware of practicing in this area, and her figures were pretty much adopted. And Maggie Sargent's report had recommended 2 waking nighttime carers. The defendant's approach, what they had done is they had costed for the next 11 years for the claimant's mother to continue to provide nighttime care. The great criticism of that was that conclusion was reached without discussion with mother. And of course, one of the factors when considering care is whether or not it's likely to be implemented. And it seemed unlikely that the claimant's mother was going to want to continue to provide nighttime care for the 11 years. And when, of course, the claimant is entitled to the provision of nighttime commercial care and indeed daytime commercial care. And so it was accepted that commercial care should be costed through the night, and the need was properly evidenced given the high level of need of the claimant and the amount of times which she worked through night and required care and support, that 2 times nighttime carers ought to be awarded. And again, it's the key for this is you need to consider very carefully, if you have got 2 diametrically opposed cases, the strengths and weaknesses of both of those, whether your expert has actually spoken to the claimant's family and whether they have expressed their wishes in a witness statement. Of course, some cases, and it's not, I think I'd be right in saying it's not too rare, that claimants and their families sometimes don't want to bring carers in if they have been providing gratuitous care, and if the care regime isn't yet set up, the claimant has to go some way to persuade the court that they are going to implement the care regime once it's available. But this was the opposite of that. They had been providing care, but a care regime was set up, and the claimants had suggested that commercial care would be accepted going forward. Experts. This is a crucial point in the case of CCC, which again will filter through to all of your clinical negligence cases and those dealing with maternity claims. The accommodation experts, the criticism of the defendant's accommodation expert was that they were less experienced in terms of the breadth of their experience. So the claimant's accommodation expert was, you'll need to read the judgment because the qualifications go on and on, but chartered surveyor, valuation surveyor, chartered builder, and I said there, etc., they do go on and on. The point was that the claimant's expert was better able to talk about the cost of alterations, and that was a key factor. But also the defendant's expert, who was an architect, had not spoken to the mother or visited the property. Now, in some instances, slightly more straightforward cases, there may actually not be a need because the adaptations that are needed are very clear from the medical evidence, and the adaptations may be minimal. But if you are reading a claimant's report and they have been to see the property and you can see that it is sufficiently detailed, you need to be meeting it. You don't want to be top trumped at a negotiation, and certainly not a trial. And so I think beware of those expert reports which are entirely desktop and which are entirely based upon internet searches. And that is a caution that is heightened where you are meeting a report which has involved speaking with the parties and has involved going to see the property. Significant criticism of the case managers on the defendant's side in this case. Defendant's expert was inexperienced and he couldn't really show any level of experience in maximum severity brain injury cases. And that was the end of his evidence, really. The finding was that he was not acting within his CPR, his Part 35 CPR responsibilities, and so the claimant's care and OT evidence was accepted. And this is a feature. There was a case handed down yesterday, again by His Honour Judge Ritchie, dealing with fundamental dishonesty, in which once again the defendant's case management expert was discredited on the basis that they lacked the experience. I think sometimes there is a tendency to use care experts or case managers that one is used to working with, and that's absolutely fine, provided that the person that you are used to working with is experienced in the area that you are dealing with. And so it is always worth going back to the CV. In fact, not just worth, I say imperative. Go back to the CV, make sure they have not just the theoretical experience, but they've got the hands-on. They have been case managing and putting in place care packages for an individual with this type of injury. Otherwise, they are going to come a cropper at negotiation stage and at trial. There was also some criticism of the defendant's physiotherapy evidence, again, for failing to provide the details of reasonable alternatives, and the paediatric neurology evidence in relation to life expectancy. So this is a case in which I'll come to this point about life expectancy. It had been agreed before trial what the likely life expectancy would be. I think it was 29. But the approach adopted by the claimant and defendant's experts was different. So the claimant's expert had approached it based on the Strauss data, whereas the defendant's expert had approached it based on median life data. And His Honour Judge Ritchie made the observation, and this is overturned, it was just an observation because the matter had been agreed between the parties, that the defendant's approach was unusual and that the claimant's approach had been typical. Leapfrog appeal. So this is another key issue to look out for. This is going to the Supreme Court. So as I said previously, life expectancy had been agreed between the parties pre-trial as age 29. And I've talked there about the data that the paediatric neurologists had referred to. And the claimant sought a lost years claim for loss of earnings and pension losses. But of course, the High Court is bound by the decision of Croke and Wiseman, so that whilst an adult who was working and may have suffered a brain injury, for instance, in an accident, whose life was cut short, could claim a lost years claim for loss of earnings and pension, a child could not when following Croke and Wiseman. Now, the permission to appeal straight to the Supreme Court has been given on this issue, so watch this space and reserve your position in relation to future loss of earnings and pension on a lost years claim in the meantime. Make sure I don't go backwards. There are many other features of the CCC case dealing with quantum. That's why I say it's a must-read. So do please look at it. I'm going to quickly look at our clock. We're already about to run over, so I'm going to just take you to the costs point very briefly. The claimant had made a pre-trial Part 36 offer. very well pitched, a gross lump sum of 7 million and periodical payments order of 360,000 for life. The court award was just shy on the gross lump sum, a little over 6.8 million, so it was lower than the Part 36 offer on the lump sum, so that had not been beaten. It was not more advantageous in money terms, and the PPO was more advantageous because it was 394,940, so almost £40,000 more per annum. C argued that all the Part 36 cost consequences should follow because they had obtained an offer that was more advantageous in money terms. His Honour Judge Ritchie rejected this argument. The offer letter was a combined offer. It dealt with lump sum and PPO together. That meant that both elements of that offer had to be beaten in order for the consequences of Part 36 to automatically apply. The claimant's analysis was that, well, if you reintroduce the multiplier, and you can calculate the multiplier based upon the agreed life expectancy of 29 years, and obviously that multiplier was adopted for the purposes of calculating the lump sum. And if you reintroduce that at the Part 36 stage to gross up the PPO offer, then of course it's a higher award and it would be beaten. But His Honour Judge Ritchie rejected that. The very purpose of having a PPO is to avoid the uncertainty of the multiplier, and you can't then reintroduce it at the Part 36 stage. And he observed that because it was a combined offer, if two individual offers had been made on the basis of a lump sum and a separate PPO, then the separate offer in relation to the PPO would have been beaten, and the cost consequences would have applied to that part of the offer. Turning away from CCC for a moment and quickly going through Turner and Sheffield, this was an interesting case on disclosure. So the claimant had suffered a severe brain injury shortly after his birth. A very sad case in which there appeared to be an unsafe breastfeeding latch, and about an hour after the baby was born, it appeared to be suffering from a brain injury as a consequence of the nose and mouth being covered. And there were significant factual issues at play as to who had observed mother breastfeeding, what might have been said and done during that hour-long period, and what might have been observed in relation to baby. The Healthcare Safety Investigation Board, HSIB, had carried out an investigation, and accounts were taken from the midwives caring for the claimant. Obviously, the case was reduced into pleadings, as was the defendant's case, and then amendments were made, which prompted the claimant to make an application for specific disclosure of the transcript and witness statements relating to the HSIB investigation. The application was made against the trust and also against HSIB. So the application against the trust was for specific disclosure. The application against HSIB was for third-party disclosure. Both were opposed. And Master Brown was dealing with this, and he accepted that specific disclosure didn't have to be, wasn't ordered, because the trust couldn't demand the disclosure of the HSIB documents. That would undermine the safe space principle. But the third-party disclosure could be ordered pursuant to CPR 31.17. But it's worth reading this. It's not going to be of wide and general application. It was very fact-specific to this case, but covering the three principles. Any document sought would likely support or adversely affect the case. It was perfectly plausible and indeed likely that those midwives that were giving evidence to HSIB would have covered the facts relating to the first hour of birth, what they observed and what their involvement had been. Was the disclosure necessary to dispose fairly of the proceedings? We're reminded by Master Brown that this is a very high bar, and that's why it won't apply to every case. But given the contemporaneous nature of the accounts and the factual dispute which would go to the heart of the claim, then on balance, balancing that alongside the confidentiality in the process of the HSIB process, it was appropriate to order third-party disclosure. And it was relevant, both here and also in the exercise of the discretion, that the midwives in that case had been told, and indeed an information leaflet is handed out at the time before an interview is given, that in some instances their interviews notes will be disclosed, and in one of those instances it will be subject to a court order, and so they were aware of that. But a Note of caution that it's not going to apply to every case. It is very fact specific, but also please note that since then, maternity investigations are now under the remit of the CQC and the Maternity and Newborn Safety Investigation. HSIB has now changed to HSSIB, and it's now been formalised under the Health and Care Act. That part of its investigation has the benefit of legal privilege. So maternity claims, hints and tips, just drawing together from some of the points that have been made throughout this morning's talk. Tips for preparation. What I tend to do with these cases as soon as I receive them is I produce a detailed timeline which sets out the counterfactual arguments on each issue. So you have the issues, and then I follow through the different, the A, B, C of if this is the fact, if B is the fact, if C is the fact, and then causatively what would have happened. So looking at the case that Francesca was discussing earlier, where the clinician was outside the room, and they would have entered the room, and one didn't need to consider what a reasonable midwife would have done in light of the bradycardia. You've got the factual evidence as to what that clinician would have done in that instance. So you're then in Belitho territory, and you can identify the need as to whether you need to cover that in your expert evidence or in your factual evidence very early on when you have your timeline set out and all of the counterfactual scenarios. Identify wide evidential needs. If you are in that Belitho scenario and you have, for instance, a clinician that is available, they go into the room and they say, well, actually, you don't need to consider what might have been done. I'm going to tell you that this is what I would have done in the circumstances, and that's within the reasonable range of opinion. In some instances, that might have a knock-on effect as to whether there was, if it's, for instance, a case of proceeding to C-section, whether there's a theatre available, whether there was scanning available. You will then perhaps need factual evidence as to what's going on in, say, the theatre at that time, and you can identify that early on. Quality of the evidence. So the expert CV is so important. Please speak with counsel before you instruct your experts, if that's at all possible. It is very easy, as I said earlier, to fall back on those that you're used to. It's very difficult. The pool of experts seems to be getting smaller and they are less available. And one thing I haven't put on this slide that I think is absolutely fundamental is that when we are at the CCMC stage and we're trying to build in time for experts' reports, if you are struggling to get, you have an expert who is on point and you need that expert, and you've got their CV available and you need more time in order to instruct that expert or have them examine the claimant, then you need to be factoring that time at the CCMC stage, because it is very difficult to get the right expert at the right time at the right expense. And you need to be thinking about this early and building in time to the CMC where possible. The case managers have to be skilled and have hands-on experience. Ensure you go back to Part 35 and just even looking at the way in which the Part 35 report is set out, even where they have the relevant expertise in, much like the case of Callahan, you need to ensure that they are giving a range of opinion and that they are dealing with each factual scenario. Otherwise, they leave themselves open for criticism. Things for the material contribution point that we touched upon earlier. Consider whether it comes into play. It's often over-pleaded, so you see it there as an add-on. Think about whether it is a divisible or indivisible injury, and whether it applies, but also, as was identified by His Honour Judge Ritchie, whether or not there is an indivisible functional element, so the consequences of the breach and whether that is indivisible, and look out for the appeal on that point, which will hopefully provide some clarity. Don't forget your tools in the CPR. So, for instance, where there are several counterfactual issues, but you feel the claimant or defendant hasn't set out their case fully on what causatively would have happened in each factual scenario, use your Part 18 so that you can narrow the issues and know that the case that you have to meet. Don't overlook the use of notice to admit facts in appropriate cases, or indeed, the parties often work well together in these cases, in my experience, and agreeing to narrow the issues at JSM stage or in correspondence. And also the vulnerable witnesses. So I've added there practice direction 1A. You need to think about whether any of your witnesses or the client is vulnerable in the proceedings, and how you're going to manage that within the litigation. Looking ahead, so these are points to just think about over the next 12 to 24 months in this area. So material contribution, as I've said, it's been described in many cases, and you can fall down a bit of a rabbit hole when you're considering material contribution when dealing with divisible and indivisible injuries. But there is more to come on this, and hopefully it's going to provide clarity, so look out for it. Secondary victims, is the door closed? Paul says it isn't closed, but one would be hard pushed to find circumstances in a birth injury case as to when the external force or accident might be satisfied. But we may see some cases where some secondary victim claims are run, so watch this space. Impacted fetal head, I've referred to that. So impacted fetal head at C-section, I'm seeing more and more of these come through as being part of the element of the case. There's been a real push for standardised training and practical training to increase consistency of approach and confidence amongst clinicians in this area. Watch out for this, because if there is some standardised training, it may give us some clarity on appropriate and reasonable levels of care as to how to manage IFH. Lost years claim, look out for the appeal there. Patient safety and incident response framework, we're going to see these, we should be seeing them now. Some trusts have been rolling them out for a time, looking at systems rather than root cause analysis, replacing the old system. So we're going to see a slightly different approach to retrospective investigations to events at birth. And then fundamental dishonesty, case handed down yesterday, Williams and Henry versus Associated British Ports Holding. Again, that's a brain injury case, but a PI, not clin neg, but it's something you should be aware of practicing in high value cases where there is any suggestion of surveillance or fundamental dishonesty. Unlikely to apply to birth injury, but report to clinical negligence generally, and be aware of it. And of course, 17th edition of the JC guidelines has now been published, so make sure you're using them. So I think that brings us up to speed. I have gone over time, but I hope you found it useful. We still have 89 participants, so thank you for that. I'm very grateful for you listening. I can't see anything. There is a question, actually. There's nothing in the chat. Let me just see if I can get to the question. Yes, it says, if the C does not pin their colours to the mast, how are DN experts expected to be able to respond? I agree with that. I think the not pin their colours to the mast is actually a suggestion that if there are going to be potential counterfactual scenarios, plead them all rather than one of them, because if you plead the counterfactual scenarios, then the parties do know the case that they're going to have to meet. And it goes to the Part 18 response that the Part 18 questions that I referred to earlier. All too often, I see, so I do this work for claimants and defendants, and when I've got my defendant hat on and I'm looking at a particulars of claim where one factual scenario is being pleaded, or potentially two factual scenarios, but with only one scenario on causation, and I'm trying to work through the various causative consequences of those, I scratch my head, and I know immediately that any judge would be scratching their head, and so I ask Part 18 questions. In some instances, there's a tactical decision not to ask the Part 18 questions because you can see the gaps and errors in the other party's case, and that must be a consideration. But I think in most cases you want to bottom this out because it's a complex, these raise complex arguments. As you can see in the case that Francesca referred to earlier, these things can evolve at trial, and in order to prevent an evolution of a claim that you can't deal with, it's better to ask the Part 18 questions and bottom it out. There's something in the chat. Thank you, very informative. Great, good. Pleased you enjoyed it. And we won't take up any more of your time. The slides will be circulated. Thank you, everyone, for joining us.
Thank you.